Going to start now. Today is the 242nd Friday group meeting. The topic is the right to redeem mortgage under Section 60 of Transfer of Property Act vis Section 13A, bracket 8 of SARFAESI Act. The speaker is our beloved senior advocate, topmost woman lawyer in this country, Ms. V. Mohana. Mohana addressed our Friday group earlier also. That is on first time specific performance relief act, that is on 4/8/2017, and second time 498 and 304B of IPC and presumption under section 113A and 113B of Evidence Act, and third time right of illegitimate child and inherent property rights, etc. Mohana ji, that's your contribution for YouTube channel, 81,000. Here it's a specific performance. First one is 63,000 it crossed.
Thank you so much.
Now you can initiate your this thing. Please, sir. I think that from here. Please, sir. Perfect.
Good afternoon, everyone. Thank you so much, Seshu. Actually, Friday group is a platform which has helped all of us to one is to learn and to empower ourselves, enrich our knowledge, and also get wide recognition. Thank you so much, and you are doing a great service. What started off as a very small affair within a small group of friends, now it has reached globally, that it has got a lot of acclaim, and viewership has increased only because of your dedication and constant working and trying to improve and finding new subjects, finding new people to speak about, experts in every field. So thank you. My heartfelt thanks to you and all of you for encouraging me and for giving me this opportunity to address you again. So like I was saying, it's not easy to address a gathering of lawyers in which everybody is actually equipped, and minimum number of practice, everybody has about 3 to 4 years, so everybody is aware of the subject, and the subject that we have taken, though it sounds a little a simple transfer of property or a SARFAESI proceeding, but it involves a lot of research and study, which so I am very thankful at the inception to thank my colleagues from my office who has really worked very hard to help me read this subject and come to you. I'll try and justify that my presence here. So this is a topic which suddenly, why we thought of this topic today is that recently there have been 2 judgments of the Supreme Court. One is that Seller, that's a main appeal in Seller, under the matter came here under section 13(8) of the SARFAESI, in which the Supreme Court has held that the right to redeem is lost by virtue of the new amendment to the section 13(8) in 2016. The right to redeem get lost at the time of the notice issuing of the calling for sale. Then there was a contempt subsequently which was filed, in which the judgment has further elaborated and Seller has been further clarified and explained in the contempt judgment. So there has been a constant talk, and we keep getting these matters. The subject that we chose is not a very rare topic or something, because every lawyer in this Supreme Court, and every one of us will be having at least at some point there is some mortgage or a SARFAESI matter or a recovery of debts matter, either for a borrower or for an auction purchaser or on behalf of the bank or any financial institution. So I thought this may contribute to some sort of a discussion here. In fact, after that, if we want, we can discuss also. I will only share the knowledge that I have learned over a period of the past few days in this. Let me tell you how it all started is about section 60. I want to first tell you what is a mortgage. Basic though, I would like to share that we should know about a little bit of mortgage under the Transfer of Property Act and right to redeem. When a mortgage is created, there is a section 60 in the Transfer of Property Act which says how do you redeem a mortgage? When does the right to redeem gets lost is what we are discussing today, because it's a very wide topic. So I'm going to confine it to up to what point of time the right to redeem survives. The right of a mortgagor to redeem is dealt with in the section 60. At any time after the principal has become due, the mortgagor has a right on payment or tender at an appropriate time and place of the mortgage money to require the mortgagee to deliver upon tender of the money. When the money becomes due, when you mortgage it, when the money becomes due, then the mortgagor tenders it and requiring the mortgagee to deliver to the mortgagor the mortgage deed and all documents relating to the mortgage property which are in the possession or power of the mortgagee, where the mortgagee is in possession of the mortgaged property to deliver possession thereof to the mortgagor and at the cost of the mortgagor either to retransfer the mortgage property to him or to such third person as he may direct or to execute, and where the mortgage has been effected by a registered instrument to have the registered an acknowledgement in writing that any right in derogation of his interest transferred to the mortgagee has been extinguished. That is, so the section sounds a little too long. What it says is the moment the money is tendered and the mortgagee is requested, he should transfer the instrument and also give back the possession of the mortgaged property if he has taken possession. There are different kinds of mortgages. Wherever there is possession involved, possession is also retransferred. This is what is contemplated under section 60. 60 has been interpreted time and again by the Supreme Court. It says that, and the right to redeem is called, on payment is due, it's called as equity of redemption. Equity of redemption means the right of a mortgagor to redeem the mortgage that he has executed. This right, according to section 60, is till the time that the sale is registered, or the section further says at what point of time it is extinguished. So as soon as you are ready with the money, once suppose it says in 3 months or 6 months or 3 years, the moment the time gets over, you redeem it by tendering the money. But they say that right can be extinguished by act of parties or by a decree of court. These are the two conditions. So today we are only discussing about how the right to redeem gets extinguished by section 60 or vis-a-vis that under SARFAESI Act, which is a special enactment. So when there is an act of parties, or that is, for example, by way of an agreement between the mortgagor and the mortgagee, supposing the mortgagor sells the right to the mortgagee subsequently, by act of parties, the right to redeem gets extinguished. Or for example, the mortgagee for some reason has brought it up in a court for a suit for foreclosure, and the suit, or in a subsequent mortgage, the same property is by way of alienation sold to somebody else, then the right to redeem gets extinguished. But the right to redeem is always there as long as the mortgage is subsisting. That is the interpretation that has been given by courts. Like we have read always, and like in England, in India, a mortgage, once a mortgage is always a mortgage, meaning thereby the right to redeem is never exhausted so easily, extinguished so easily. So now this has been actually interpreted in several judgments of the Supreme Court. One of the very important judgment in this series of section 60, which is one of the oldest, is that Narayan Das Karsandas, which in all the subsequent judgments even till date, which is referred to, is Narayan Das Karsandas. This is 1977, 3 SEC 247. In this, what was actually discussed was, there was a mortgage in which the property was sold by the mortgagee, and the mortgagor claimed his right to get the redemption. But only what the Supreme Court said, by virtue of section 54 of the sale of the Transfer of Property Act, a sale is the sale can only the registration of a sale only affects the transfer of right in the property. So therefore, unless there is a registration of a sale deed, the right to redeem does not get extinguished. In India, the transfer is recognized only, a sale is recognized under the Transfer of Property Act under section 54. 54 says anything above rupees 100, any immovable property has to be transferred, will have to be effected by a registered document under the Registration Act also. So therefore, in Narayan Das Karsandas, what was held is that in wherever, even assuming there is a agreement to sell, or even it is up to the point where the agreement has been entered into, or even the mortgage has fixed the price and the mortgagee has fixed the price and the auction purchaser has agreed to sell, till the time the sale deed is actually effected, the right to redeem is not lost. So that is the principle evolved over a period of time under section 60. So therefore, there is only one owner in as far as the property is concerned, that is the registered legal owner. That's what this judgment actually said. The paragraphs 34, 35 and 37 of Narandas Karsandas will deal with this. It says a transfer of immovable property above rupees 100 without registration does not extinguish the right to redeem. Equity of redemption is not extinguished by mere contract of sale. So therefore, in this, the auction purchaser's appeal was dismissed, holding that there is no real sale actually. That is what has been time and again interpreted under section 60. Now, we have to see when there is no special term like for redeeming during mortgage, the right, when does it expire? Like Act of Limitation Act that you have said last week, only you have heard a lecture on that. As far as mortgages are concerned, it is a 30-year period from which when the right to sue accrues. So, whenever the payment is due and thereafter up to 30 years, you can get the right to redeem the property, assuming the right of foreclosure is not exercised by the mortgagee. Foreclosure is the right of the mortgagee who has given you money and taken the mortgage. Suppose, assuming I am the mortgagor, the person who has got the property and taken the money, he has a right to enforce it by filing a suit for foreclosure, and till the time that he doesn't do it, I get the right to redeem as long as possible. But once the amount is due, it is a co-extensive right of a mortgagee to enforce the mortgage also. So he can go to the court saying that there is such a mortgage, so there is some money due to me under this mortgage, so I want to get the charge over the property decreed, and thereafter by selling this property I can get the money recovered. That is covered under all this redemption and mortgage, the suit for foreclosure, they are all covered under Order 34 of the Civil Procedure Code. There is always a preliminary decree which is passed. As far as the case of redemption is concerned, it will find out as to what amount is due. Whenever you file a suit for redemption, we don't have to actually deposit the money at the time of filing it. It is determined in a preliminary decree under Order 34 of Civil Procedure Code. It says, 34 says there are stages when you say that this is at what point of time, what amount is due, what is the interest as per the contract, and what is amount to be tendered. So after that, there is a preliminary decree which is passed, and subsequently, if the amount as determined within the time frame as fixed by the court in the preliminary decree, if it is not tendered, then the mortgagee has a right to apply for a final decree as such in a foreclosure. So like in a right of redemption also, in a foreclosure also, only after the final decree is passed and the sale is effected, the right to redemption gets lost as far as the mortgage is concerned. So it's always very tough to defeat a right to redemption in case of a mortgage. So it always subsists, which is why we call it once a mortgage is always a mortgage. Now coming to this right of, that there is always another concept called a clog on redemption. What is a clog on redemption? It is a restriction on the mortgagor of his right to redeem. Like for example, in a mortgage, they say that in 3 years' time, if you don't redeem the mortgage, then the mortgagee will be the owner of the property. That kind of conditions have been held to be void, and the courts have interpreted that these are all called clog on redemption, because the statute, section 60 is a statutory right. So when a person has a statutory right in respect of redemption or even the foreclosure, the statutory provision will have to be given effect to. In that event, if there is a condition which is prescribed which will curtail your right to get a redemption, or even illusory mortgages like 99 years this mortgage will subsist, you can't redeem it till the time it is 90 years or something, a condition which cannot be actually applied, they are called as clog on redemption. They cannot even be recognized, assuming it is put in the as a condition in the mortgage document as well. They will not be held to be valid and they will be struck down. That's a small angle on the clog on redemption. And a right to redeem who can exercise is actually section 91 of the Transfer of Property says who all can redeem a mortgage. For example, a successor or even a purchaser of a mortgage redemption rights, they can exercise this right, and they can at any point of time. And one more aspect is, which I read over a period of time, is that even if you file a first suit for a redemption and if it is dismissed for some reason, as long as the foreclosure is not done, as long as the sale is not over or registration has not happened, you can subsequently file another suit for redemption also. So successive suits for redemption can also be filed. These are all simple, smaller points for mortgage, because we see that normally we would think there is one redemption suit which has been dismissed. Can we ever be permitted to file a second suit because it has been subsisting? As long as it is not foreclosed or no sale has happened, we have a right to file a second suit as well, till the time a final decree is passed under Order 34. This is the rights still subsist. Actually, as I said, the right to redeem has to be exercised only before the enforcement of the mortgage. Now, there is this is what in the normal mortgages were going on, and what happened that after some time, these are all like the right to redemption till the delivery of what do you get during a right of redemption. Also, I'll say delivery of mortgage deed, possession and reconveyance, and it's only by court order or by parties that the right can be extinguished. Now, this was all the normal redemption rights under Section 60 of the mortgage, which has been time and again enforced. Even today, Section 60 is the general law as far as every mortgage is concerned, and every, even otherwise, even institutional mortgages or everything. What has now come, the subsequent years, what happened was, the banks which were all taking the properties on mortgage were finding it very difficult to get the money back from the debtors, and they were finding it very impossible to get the recovery of the dues. Though they were having the immobile properties, though they were enforcing the mortgage in proceedings, in 1993, of course, the Recovery of Debts Due to the Banks and Financial Institutions Act came, RDDB Act, which we normally used to go to DRT. The banks used to go to the DRT, that is the debt recovery tribunals were established, and subsequently the dues under that RDDB Act were enforced there, where people were also filing applications after applications and contesting their rights, and suddenly it will come for an auction, mortgage, the auction purchaser will take it in auction. However, subsequently on different applications, these rights could not be exercised, and the auction purchasers were also finding it very difficult. The people who want to take properties in auction were finding it difficult to take these properties, even genuine purchasers, and the banks felt there was too much difficulty. That is when there was so much challenge. So that is when in 2002, the SARFAESI Act was brought in. We need to know a little bit about SARFAESI Act to understand the 13(8). SARFAESI is, we call it shortly SARFAESI. It is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Whatever the assets which are mortgage, they call it a secured asset. And the Act was brought in due to certain studies made by the Narasimham Committee in 91 and 98. There were 2 reports, and the Arjuna Committee. You all will know, and the Arjuna sir was a senior advocate practicing here. He was also one of the members. He also gave a report. Based upon these 2 committee reports, this enactment was done in the year 2002. This had because the object was to see that the banks and financial institutions were about to take action. They wanted to take action without recourse to court. Such a remedy was already available in respect of certain mortgages in the transfer of property, which is mentioned at Section 69. So therefore, Section 69 said, whatever is a mortgage of any person acting on his behalf shall, subject to the provisions of this section, have power to sell or concur in selling the mortgage property or any part thereof in default of payment of the mortgage money without intervention of the court in the following cases. It's a long section. It is fully described. Section 69 of the Transfer of Property Act already had a provision by which certain mortgages, and by way of agreement, the parties could agree to sell these properties without intervention of court. So this SARFAESI, actually the Act also enabled the banks and financial institutions, irrespective of whether there is an agreement between the borrower and the creditor, whether there is an agreement to sell it without reference to court or not, irrespective of anything, such a power was given by this SARFAESI. The whole idea was to help these. I'll just read 4 lines from this object and reasons of this. The first act in 2002. The idea was Mardia Chemicals deals with it. Financial institutions, namely lenders who are duty to act fairly and in good faith, there has to be a fair dealing. So that is Mardia. But the object and reasons, the financial sector has been one of the key drivers in India's efforts to achieve success in rapidly developing its economy. While the banking industry in India is progressively complying with the international prudential norms and accounting practices, there are certain areas in which the banking and financial sector do not have a level playing field as compared to other participants in the financial markets in the world. There is no legal provision for facilitating securitization of financial assets of banks and financial institutions. Further, unlike international banks, the banks and financial institutions in India do not have power to take possession of the securities and sell them. So therefore, the existing framework was not sufficient to keep pace with the changing commercial practices. So this act was brought about with this object in mind and several other. So this act was challenged. This act had several provisions like giving a notice as soon as the money is due and then getting their reply, then finalizing the amount of dues after taking the objections, then taking possession of the property and then selling it in auction or by private treaties. Those were all these sections were there. There is a section 13 which deals with all these provisions, and 14 was taking possession, 17 was the remedy by going to the DRT, and 18 appeal. Like that, there was a full sequence. It was a self-contained code. This was challenged in the Supreme Court in the judgment called Mardia Chemicals. It came to the Supreme Court. In Mardia Chemicals, which is reported in 2004, the provisions of this enactment was upheld. It said, the Supreme Court said that the object and reasons are very valid and the provisions are only aiming with this objective in mind, so therefore there is nothing wrong except in two areas what they said. Whenever there is a possession taken and the property is brought to sale, when we want to challenge it, the DRT said under 17 that 75% of the amount has to be deposited. The amount due which is demanded has to be deposited. So that the Supreme Court said that will be a little illusory for anybody to have come and found. There may be any other reasons by which a mortgage can be, the sale can be challenged. So if you are insisting that 75% will have to be deposited, it will render the relief itself negatory, so illusory. So therefore, that was modified, giving it the discretion to the tribunals to reduce it. And also there is another provision which said section 13, when the 13(2), when there is a notice sent by the banks or the financial institutions to the borrowers can make a representation. It's a 30-day notice. But after that, the borrowers can make a representation and they can explain their circumstances or point out any other objections. There will be a proper hearing subsequent to that. You can't straight away go to the 13(4) without resorting to a hearing. However, a caveat was given in that judgment itself that hearing doesn't mean subsequent to this you will get another challenge, another opportunity to challenge it at that point of time. It will be only that you will get an opportunity of hearing where you can go and explain how you are not liable to pay or this is what you can pay, something of that sort. However, we can't get you another hearing on this ground, is what the Supreme Court said. So therefore, the proceedings were going on. Now to go to that SARFAESI, we should understand what is certain sections before we understand the redemption. 13(1) said the measures are like 13(1). 13 is the enforcement of security interest. I am not going to read it fully, but I am just making you aware of this. Of course, all of you know this, just as a sequence. Enforcement of security interest is dealt with under section 13. This says, notwithstanding anything contained in 69 or 69 capital A of the Transitory Property Act, any security interest created in favor of any secured creditor may be enforced without the intervention of the court or tribunal by such creditor in accordance with the provisions of this Act. So, notwithstanding anything under 69 or 69A, only two provisions. 69 is what we saw is particular mortgages without intervention of court. 69A is for appointment of a receiver by these people to get hold of the property and to get it sold. That is that 69 capital A. So what it meant was, irrespective of only those mortgages which are covered under section 69, this provision will now cover all sorts of mortgages, all sorts of the security interest which has been created in all institutions and banks, they can take proceedings against the secured creditors can take proceedings without intervention of the court, but in accordance with the provisions of this enactment. This is a special enactment. SARFAESI is a special enactment for enforcing this security interest as far as these are concerned. That contains certain conditions. 13.2 is that initially when there is a default, the banks or the financial institutions or the secured creditor will be giving you a notice stating this is the amount due, this is what we have found, this is what you have been declared as an NPA, because non-performing asset and classified, and therefore you have to pay this much of amount. So in the event of non-payment, the other steps in this act will be taken. Then after the Madhya, the 3 that will give details, but 13.3 capital A came into picture, that is, it came in 2004. If on receipt of this notice, the borrower makes any representation or raises any objection, the secured creditor shall consider such a representation or objection, and if the secured creditor comes to the conclusion that such a representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such a representation or objection the reasons for non-acceptance of the representation or objection to the borrower, provided that the reasons so communicated or the likely action of the secured creditor at the stage of communication of reasons shall not confer any right upon the borrower to prefer an application to the DRT under section 17 or the court of district judge under 17A. This is what Madhya held, which has been inserted as a provision 3 capital A, which said that normally what would happen, 13.2 notice would come, we will file our objections, there will be no reply, the bank is not, they are not concerned, they will keep it and then they will proceed with it. The only extra opportunity that we got was you have to reply, whatever is the objection, you will have to reply within a period of 15 days and then you can further proceed about it. Whatever is but for that reply, if we are agreed, that a borrower will have to wait till the time that he approaches. So therefore that is not a justiciable action, is what they say there. So then subsequently what happens under 13.4, if after all these things the borrower, after the communication also, if still he is not depositing or paying the money, then 13.4 is they are entitled to take recourse to the following measures, that is to take possession, if it is a property, any individual or anything, or right to transfer that property in lease by way of assignment or a sale for realizing the amount due, take over the management if it is a business, and provided the right to transfer, assignment or sale will be exercised only where the substantial part of the business is held as a security, etc. There are certain conditions for taking that also. So if it is a business, it can be taken over or transferred, or if it's a property, they can take possession of it. Section 14 also enabled them to take possession through approaching a magistrate. That was also been separately interpreted, how to take possession, etc. So that is 13.4. The recourse is only if the money is not paid, is 13.4. Then 5 to 7 is about how adjustments are made, etc. Then comes 13.8. 13.8 as it existed and as it exists now is what we need to see. See, we are today on the right to redemption when it gets extinguished. So therefore 13.8 becomes very relevant here. Originally 13.8 as it stood is, if the dues of the secured creditor together with all costs, charges and expenses incurred by him are tendered to the secured creditor at any time before the date fixed for sale or transfer, the secured asset shall not be sold or transferred by the secured creditor, and no further step shall be taken by him for transfer or sale of that secured asset. We will stop here for 2 minutes. See what it means. 13.8 originally as it existed till 2016 is whenever a property is, after 13.4 steps are taken, if for the amounts due, if when it is tendered to the secured creditor by the borrower or anybody claiming under him, that amount due with the cost, etc., the expenditure incurred for advertisement or taking possession, etc. The moment it is tendered, at what point of time? Before the sale is actually effected, before the date fixed for transfer, then no further steps can be made by the secured creditor, is what 13.8 said. How it has been interpreted is what I will just tell you. What courts have done time and again as far as the existing 13.8 is that they read section 60 along with 13.8, and then they say 13.8 contemplates a situation where money can be tendered till the time a registered sale has actually happened. So Narandas Karsandas has been followed from time and again for interpreting 13.8 to say that though there are two more provisions in the SARFAESI Act which I would like you to see, is that section 35, which will be relevant, 35 and 37, because 35 says the provisions of this Act, SARFAESI Act, shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any law. So 35 gives an overriding power, notwithstanding anything inconsistent therewith contained in any other law for the time being. This has been interpreted to mean any other similar law, securities law. That I will tell you. So 35 and 37, application of other laws not barred. The provisions of this Act or the rules made thereunder shall be in addition to and not in derogation of the Companies Act, Securities Contract Act, SEBI Act, Recovery of Debts and Financial Institutions Act, or any other law for the time being in force. So these are two different provisions. 35, while it says it has an overriding effect, 37 says the application of this law will be in addition to and not in derogation of these other laws. Just keep this in mind when you are doing the 13.8. So subsequent to this, Madhya and SARFAESI and all this, certain challenges were, they kept coming, because there were matters where, the first one which came was, which was dealt with is in, there are so many, but what I thought was for the time being we can adhere to few of them. One is a central bank versus state of Kerala. This was about the conflict. There was a question in this judgment is whether the SARFAESI and the DRT Act, we call it shortly RDDB Act, will have precedence over the Local Sales Tax Act. Because in the Kerala, that was one was a Maharashtra, one was a Kerala Sales Tax Act, they had priority over these mortgages, the securities. So when there was an argument, this is a 2009 4 SEC 94. This judgment deals with, this is one of the interesting point, is that whether there was a conflict between the Central Act, which is the DRT Act, and the SARFAESI Act, and a state enactment as far as the recovery of dues for sales tax is concerned. But the Supreme Court says nothing in the central enactment will say the bank's dues will have predominance as against any other dues of other parties. It merely enables the security interest to be enforced and amount taken without having recourse to courts. However, there is nothing to mean, because these two operate in different fields. The central enactment is on a recovery enactments, whereas the sales tax is of the state subject. In that subject, there is no conflict between these two enactments. All that it says is there is nothing to show that the first charge is always in respect of the bank, because it is a central enactment. So therefore, in that particular case, it was decided the state rights are not subservient to the bank's dues. And the first charge in favor of the state means it will have primacy over the bank dues. It was what the first issue on the legal angle as far as the other enactments are concerned. Now the question is about this, how to, at what point of time the redemption right was lost as far as the original provision as it existed, 13.8. There were other cases, a lot of cases were there, but of importance which I would say is that one is Vasu Shetty. One is Vasu Shetty. It is a 2014 5 SEC 660. It says, unless expressly waived by the borrower, bank has to follow rules strictly. Here I want to tell you that there are certain provisions in the rules which will have to be taken into consideration. That is, the security interest enforcement rules. When we are all dealing with 13.8 about right to redeem, at what point of time it can be given. When the property is brought for auction or for any type of sale, there are certain provisions which the creditor will have to keep in mind for effecting the sale. So if you see section 4 onwards, you can see the one is sale notice, rules. If you come to security interest enforcement rules 2002, rule 5 says valuation of movable secured assets. It has to be after taking possession under sub-rule 4.1, and in any case before the sale, the authorized officer shall obtain the estimated value and thereafter, if considered necessary, fix in consultation with the secured creditor the reserve price of this. So, fixation of a value, which is very, very important. Rajiv Subramaniam says you have to get the valuation done so that you get the best price out of the mortgage. People are always in dire straits when you come to the, when you effect a mortgage and you are unable to recover that, the mortgage property, and then you are unable to pay. What is the balance will have to be struck. As far as the properties are concerned, the secured creditor needs the money. Sometimes the nationalized bank, the public exchequer suffers. So therefore, the amount should be the maximum that you can get, which is why a proper valuation is done and appropriate value is fixed, which is very important for these purposes. Sale of movable assets are considered in Rule 6. For movables also, there is a methodology. How do you get guidelines? How do you get quotations? Inviting tender or private, or even by holding a public auction. All these are sealed quotations. These methods are to be followed as per Rule 5. It has a complete procedure and there are forms prescribed by which you have to effect this. And issuance of certificate of sale will be for a movable as well as for immovable. There is a separate procedure. Sale of immovable secured assets is contemplated under Rule 8. What is the step that you will have to do, and after taking possession, what notice will have to do, how many days notice is there, and how do you effect it. Rule 9, time of sale, issue of sale certificate and delivery of possession. So Rule 9 says, originally as it existed, had different time frame. After this, in 2016, again Rule 9 also got amended. I will come to the Rule 9. Rule 9 fixes a time of sale and what is the number of days of notice that one has to give for this, effecting this sale. Because we have had any number of judgments as far as the dates are concerned, like sometimes the first sale will have to be 30 days, second one thereafter, if it is not completed, only because there were no purchases or because due to some other reason or a court stay order or anything, if the sale could not be effected, there will be a second, there will be a third, 9, 10, there have been any cases where there have been 9th, 10th number of times the properties have been brought to auction, not successful. So all these steps, the Supreme Court says, is that any number of times it may be brought for auction, but the right to redemption is not lost only because it is brought for auction. As the 13.8 existed, the right to redeem gets lost only when the sale is effected and after the sale certificate, the sale is registered. That is the interpretation which the Supreme Court has given. We will say in Vasu Shetty is one of the older ones, where in fact the borrower said the procedure is not followed and the time frame, and we were wanting to follow the OTS. We had a one-time proposal, the bank did not agree, so therefore the sale effected during the talks is not proper, the number of days notice is improper, valuation is not proper, all that. However, what the finding has been done is that, the bank's argument was this. There was an OTS proposal. The borrower said he will come and he will pay it. He agreed for the OTS proposal. Now he has given up his right to challenge the sale. So therefore, since he has agreed to pay, he cannot challenge the sale. But the Supreme Court said no. A borrower has a right till the last minute to redeem his property. So therefore, unless expressly or by an agreement, borrower gives up his right to challenge, or by conduct, unless it is expressly waived, the other conditions need not be followed. There is no question of any implied waiver in these matters. So therefore, following the procedure is very important, despite the fact that there is an OTS arrangement. So the bank is not relieved of its obligations, even though there is an OTS agreement. There is no waiver in the case. So therefore, mandatory conditions have been breached. So the sale is null and void, and 2 months was granted to the borrower in that case to pay. Otherwise, a fresh sale will be notified, is what the Supreme Court said. That's one of the off-court judgments, is Vasu Shetty in this. That is in 2014. And subsequently, we have this Alokam Peddabaya, where it was otherwise. And see, what happened was the purchaser of a right to redeem failed to pay or take steps after the suit for foreclosure was filed also by the creditor. But the Supreme Court said that assuming you are a purchaser of the right to redeem, your rights are not better. So therefore, for you also the same steps will have to be followed. And time and again they do take notice of the section 60 principle of, because in India this is a general law. Of course there is a special law is SARFAESI. Nevertheless 13.8 has been interpreted as alongside, and then they say that the right to redeem will be there till the time the actual sale gets effected. And one of the very important judgments are in that, another one is Matthew Varghese versus Amrita Kumar, which you will find in any securitization judgment or any mortgage sale. You will find this judgment being quoted. That is 2014 5 SEC 610 paras 29 to 39. Here what happened was, property was brought for auction. A mandatory notice, sale notice is 30 days as per the old provisions were there. Rule 9 then existed. Today even in 2016 Rule 9 is also amended, and Rule 9 as it existed, 30 days notice was to be given. In Matthew there was a court proceeding, and the borrower approached the High Court. The High Court said the DRT will have to decide it. However, 6 weeks time was given to the borrower to redeem the mortgage. In this, and the amount was fixed. But in the 6 weeks also, the borrower could not redeem it. So therefore, though the sale was not happening, the DRT continued with the proceeding, and finally his securitization application got dismissed. The second sale was effected immediately after the SA got dismissed. So the challenge was whether a fresh notice should have been given by giving 30 days notice. As per original Rule 9 is always 30 days notice will have to be there. Subsequently only it has been amended. So the court interpreted it to say that though the original 13.8 is always giving opportunity to redeem borrower till the sale is effected, principles of section 60 is as stated in Narandas, Kasandas is followed. What it says is section 60 of the Transfer of Property Act has full application. In this case actually there were two portions. Matthew had two portions. One, it said yes, High Court in the division bench said that in fact he lost in the writ court, and then the borrower came to the writ appeal. He said the High Court reversed the order and gave benefit to the borrower. It said it gave some time for the borrower to redeem the mortgage. Again he didn't pay the money. He filed an application for extension. That was allowed by the division bench. Then he paid the money. The auction purchaser came to the Supreme Court. The Supreme Court said there are two portions. One, section 60 has to be followed. Till the time a sale is registered, the right to redeem is there. However, in the present case, a last opportunity to right to redeem was given by the court, and the DRT subsequently SA got dismissed. The High Court also dealt with it, and in the division bench there was a time fixed, and the auction purchaser had already paid the money. Sale certificate had been effected. But the extended time given by the division bench is wrong, because once a time for this has been fixed and he has not complied with it, it is not proper for the High Court should have extended it, and therefore his right to redemption is already lost as per the existing provision also. So Matthew Varghese deals with these provisions elaborately, and it's a very very eloquent judgment which talks from paras 29 to 39, which you can rely on for any other similar cases. And finally what he said was asking the auction purchaser to make some additional payment. Subsequent to this came Dwarka Prasad, which is also one of the most relied upon judgment, 2018 5 SEC 491. This is by our learned Chief Justice Chandrachud. Para 9 deals with it. It says, they also rely upon Matthew Varghese. Here, the right to redeem, he again reiterated that sale was confirmed and sale certificate was issued. The borrower didn't exercise his rights properly. In between, the sale got registered also. He came to the court with the right of redemption only after the sale got registered. So, para 9 in Dwarka Prasad says the right to redeem gets extinguished. That was 13.8 only. But even there, they gave the right till the time the sale got registered. So the Supreme Court notices the sale got registered. So therefore, thereafter you lose the right, even assuming sale certificate is given. In fact, the law is in public auction, Section 17 Registration Act itself would say, we saw it, that in a public auction, in fact, there is no need of a registration. If the public auction is effected by a public officer or an authorized officer by the government, there is no need to separately effect a registration. However, in these cases, they have said these auctions, there are two views on this also. But in Dwarka Prasad it says, since the sale has not been registered, till the time the sale is not registered, you have a right to redeem the property. So the borrower didn't use it actually. That is Dwarka Prasad. So these things were going like this, and there is similarly Mohana packaging is there. Finally in that line comes Karthik. It's 2022 10 SEC 641. That is thereafter which we will enter the latest arena. 2022 also is after 2016, but it concerns a property, a sale which happened prior to the amendment in 2016. 13(8) amendment in 2016 is most crucial for all of us, because seller interprets and takes away the right to redeem at some point prior to what we were now seeing till now. So Karthik actually clarified. Only difference in Karthik case, it's called S. Karthik versus Subhash Chand and others. Here also, it was a case where first sale notice was given, 30 days notice was given. The borrower went to court and got an order of stay. Subsequently, the stay got vacated and the second sale was not effected. Then before that, I would say, Rule 9 got amended in that 2014 also, 2016 also. So therefore, before that, in the Rule 9, the 30 days notice was contemplated. Every time a sale has to be effected. In Karthik's case, what happened? The guarantor went and took a stay. After that, the court observed the conduct of the guarantor and the borrower to be not good, because several opportunities were given for redemption. They never availed it till the last minute, and the second sale was immediately it took place. They challenged it on the ground that actually there is no 30 days notice subsequent to that, so therefore this is void. But what happened was the sale got effected in between in 2012 and it got registered also. But noticing the conduct of the guarantor and the borrower, the Supreme Court holds that though there is a right for a sale to be effected and till the sale is effected, the right to redeem is there. In this case, the first sale notice got stalled by a court order at the behest of the guarantor. So therefore, it is the conduct of the guarantor. Here this may be a little arguable, maybe in a different set of facts, maybe we will be able to argue that in different circumstances. In this case, due to conduct of the clients, the court has noticed second sale need not be having a 30-day period. They distinguished Matthew Verghese. Though the Matthew Verghese says for every sale there has to be a 30-day fresh sale notice will have to be effected under the old existing provisions of Rule 9 also. Here there is a distinction which says because of the conduct, despite all opportunities not having been availed, there is no question because the guarantor took a court order and stay. Whether we can still argue it is something which is open for us. Because every sale notice, if I have to go and ask for a stay, even Matthew there was a stay. High Court had granted a stay. So, but however, that was not taken against the borrowers for that. Because when there is a legal remedy available to you, approaching a court of law for availing your legal remedy, whether that can come in the way of reducing the period of sale notice is something which we can say in a fact situation. Here in Karthik they say you can't get a second notice, 30 days period. So therefore they didn't come in help of borrower. So these were all happening. When this was all happening, there was an amendment in 2016 to the SARFAESI Act, which actually enabled further, and certain one or two amendments have taken place. The predominant amendment which we are talking about is an amendment which has happened to Section 13(8). Section 13(8) now changed the language. Originally, the section said till the time the property, the date is fixed for sale or transfer, which is interpreted to mean that till the time it is actually registered. Now 13(8) says, I think many of us may not have noticed why seller is like this. Because of this new 13(8), which is where the amount of dues of the secured creditor together with all costs, charges and expenses incurred by him is tendered to the secured creditor at any time before the date of publication of notice for public auction or inviting quotations or tender from public or private treaty for transfer by way of lease, assignment or sale of the secured assets. The secured assets shall not be transferred by way of lease, assignment or sale by the secured creditor, and in case of any step is taken, then no further proceedings will take place. So what has happened here? What 13.8 gave us originally was till that time a real sale is happening. Here, till that time a public notice of sale is effective. So therefore your time of approaching for redemption is actually brought down, is what it has been interpreted. Of course, there was an argument. There is an argument which says the object and reasons of 2016 amendment doesn't say anything about bringing down the time. It merely said 13.8 will also enable the secured creditor to do it, otherwise not. But 13, there is no separate aim and object for 13.8 amendment. It can be read to mean till the time that leasing and inviting private treaty were all not there in the original 13.8. Maybe we can interpret it to mean that whether any lease was happening or a private treaty was happening, that right will get extinguished. I mean that till that time nothing will proceed once I tender, can also be interpreted to mean that. However, what has been interpreted after this is what is of concern for us today, which further we will have to examine. In this 13.8, along with that, what had happened was Rule 9 has also been amended, which says just one thing. Seshu, are we running out of time?
No,
we have
fine.
time.
Perfect,
Okay,
yeah.
just another few. One judgment.
Yeah, please.
No sale of immovable property under these rules in first instance shall take place before the expiry of 30 days from the date on which the public notice is published in newspapers as referred to in sub-rule 6 of Rule 8, or notice of sale has been served on the borrower. Provided, further, if the sale of immovable property by any one of the methods so-and-so required to be conducted again, the authorized officer shall serve affixed and public notice of not less than 15 days to the borrower for any subsequent sale. So, this has been now initially 30 days, and if something doesn't happen due to any of the reasons which is quoted, then it is 15-day notice which has to take place, is the new rule also. That is new Rule 9. We'll keep that in mind. What happened was, a matter which came to the Supreme Court and which is now of serious interest to us today is that Celir LLP versus Bafna Motors, which is by our learned Justice Padiwala, 2024 2 SCC 1 is the judgment, which is which now is followed up by another contempt judgment in the same matter also, which has explained this also. In this matter, what had happened was, the borrower had gone to DRT. SARFAESI proceedings were initiated against him, so he went to the DRT, and it was more than 100 crores, 105 or 109 crores amount due to the banks. So he approached and he said, under 13.8 proceedings were taken for sale. He approached the DRT. However, in the meantime, the auction sale had also happened, and the bank, by the time the hearing was taking place, he also moved an application for redemption of the mortgage. There were two things in this. One is, he approached the DRT by saying that the sale has not been effected as per the procedure contemplated under the SARFAESI rules. One. That is one of the objections. 15-day, 30-day period not complied with. While that is pending, and when the bank was about to enforce and the auction purchaser is coming into place, the bank's applications was heard. He filed an application also in the DRT for redeeming. We know redemption means tendering the entire amount which is due, and this is apart from getting the sale set aside. Sale set aside need not mean the property will be coming back to you. It may again go back to the secured creditor. At that sale may not be the proper sale. It may conduct again also. But what happened here? Despite challenging the procedure, he also moved an application by tendering the money and then said, I want to redeem my rights, redeem the mortgage. These two were heard by the DRT and orders were awaited. Somehow the borrower felt that we have to go to the High Court. So he approached the High Court on the basis that 13.8, his right to redeem is not lost. So therefore, he wants to redeem the mortgage, and he wanted a direction from the High Court permitting him to redeem the mortgage and a direction to the bank to allow him to redeem the mortgage. Now the point is the High Court, the bank also he offered another 10-15 crores over and above the amount which was due. The bank was also happy with that. The bank also accepted and the High Court passed an order say allowing the redemption, forgetting all that. During the course of the proceedings, in the orders it is coming out as if the borrower had told the court that he is not going ahead with the challenge to the procedural violations which has happened in the matter, and he will stick to the validity of his right to redeem under section 13(8). So therefore what he did was that my 13(8) is now right. There is nothing that has taken place as far as, because I have tendered the money before the DRT proceedings are over, before the sale is confirmed in respect of the auction purchaser. So therefore my redemption rights are not lost and I undertake to withdraw all the proceedings before the DRT. So I wish to continue this. The High Court recorded all this in several proceedings and finally the High Court allowed the petition filed by auction purchaser approached the Supreme Court. This is the judgment which is now latest on the new provision, which is actually 2024 2 SEC 1. The Supreme Court heard it at length and passed this judgment allowing the auction purchasers appeal, saying and interpreting the new 13(8). It says in so many paragraphs that 13(8) as it existed originally could have helped a borrower to redeem the rights, referring to Matthew Varghese and Narandas, Kasandas, all those judgments under 60. The Supreme Court also says 60 contemplates one situation, that is, a right to redeem can be lost by act of parties or by a decree of court. This, I will say, will come under act of parties because it has already taken place. So therefore, there is no violation, and in any event, the borrower having not approached the court before the date fixed for public notice as contemplated under the new 13(8), right to redemption is lost. So he has interpreted it in a beautiful judgment, paras 64, 65, 69 and 107 to 109. They say Transfer of Property Act and SARFAESI Act are complementary to each other. There is no difficulty in interpreting. That is where he says, we can argue, 60 says till the time the sale is registered, my rights are not lost as a borrower. But the court says 60 also has a proviso. Says your redemption rights are lost when? By act of parties or by a decree. Here there is already a court order which has been auctioned and there is an auction purchaser. And read with 13(8), it says your rights of redemption is only till the time a notice for sale is given. So that is where it says, and transfer of property would not be in addition to SARFAESI. SARFAESI is a special enactment which is complementary to the Transfer of Property Act. Otherwise, all these actions and will be rendered, all the auctions which are happening time and again will be rendered meaningless. If everybody can come, then 13(8) is just rendered nugatory if you are going to say that every time. So auctions cannot be interfered with easily. And we all have done auction purchasers matters also. We have done some judgments in which beginning from 67 onwards that when you have a auction purchaser who is a bona fide purchaser without notice also we have done with all intentions, and he has blocked his money for so many years. His rights are to be protected. We have got judgments to say, even assuming when the sale is supposed to be invalid also, the auction purchaser's rights are always protected. So the court noticed all these provisions and then came to the conclusion, and an argument under equity was also advanced. Equity is there, so you have to allow me. Under equity, I have now tendered entire money which is now with them. The bank has taken the money also. So under equity also you have to give me benefit. The court says equity can only supplement the law and not supplant it. So therefore, the judgment is very well written. Initially for an onlooker, just to take a judgment in seller and then to say, how do you say in 13(8) suddenly you are losing the entire redemption rights, means you have to go through the new amended provision which only curtails it to certain things. So therefore, which has stopped the right at that point, which is curtailed it, not till the date of sale, but as an amended provision, which is now interpreted to mean that only up to the date of public notice that a sale can be, that a redemption can be effected by tendering the money which is due. But what happened, it didn't stop there. What happened was, this after this judgment, even when the case was going on, after the High Court judgment, the borrower had transferred his right to another third party. So they all went back after this judgment. This judgment set aside that High Court judgment and then said give back, and the bank had given a sale also in favor of the borrower. We transferred everything. There were certain directions given in this judgment to retransfer everything, give the original title deeds, etc., etc. After this judgment, the DRT matter was pending. We all remember now. Originally, the DRT case was there. Before the judgment could be pronounced, only borrower approached the High Court. So he goes back to the DRT. Auction purchaser, the subsequent transferee also goes. They say that there is a violation under Rule 9. When the sale took place, there was no enough notice. That is 30 days plus 50 days notice. That 15 days notice, the 30 days notice or the 15 days notice have been violated. So therefore, the sale is invalid. This is an additional remedy which I have under the SARFAESI. So therefore, they went to the DRT. The DRT heard it fully, dismissed it. However, they went to the High Court and the High Court also. But here, the auction purchaser came here and then said, this is what has happened. So there is a contempt on the face of the judgment. There is a contempt is what was filed, which is also reported. The contempt judgment in Celir is also reported. If I am not wrong, you can get 2024 SEC online SC 3727. 13th of December 24 only it got reported. This is a judgment. Just a few lines only I would like to say. Nothing much in the sense I will not take much of your time in this. I will say this is what they said. They go through the entirety of the contempt, and then this is a very elaborate judgment. It not only deals with the aspect of law of contempt in a beautiful manner, also takes notice of the fact fully that what was argued. Once we see this judgment, maybe we can think about whether the violation to an enactment has been foreclosed by this judgment or not. Because there is one set of thinking after Celir is that once your right to redemption is lost under 13.8, so therefore can you not challenge a sale which is actually violative of certain provisions of the rules? So that also is replied in the contempt judgment, which says, this is the one. In this judgment, the Supreme Court says, 1, the borrower's submissions were all in fact quoted and then said, even in the High Court, he had given up his right for challenging it under various provisions of the SARFAESI rules, and he had undertaken to withdraw the DRT proceedings. There is a specific paragraph which says, had it been his case that he will argue all the provisions, all the rules also, that there is a violation, it's another aspect. But what did you all confine yourself to? You said we are only confining ourselves to 13.8, right to redemption, at what point it is lost. So therefore, since it is only lost on that pretext only, there is no question of again re-litigating it. So on the issue of res judicata, constructive res judicata, what could have been, ought and might could have been argued is also dealt with. Second aspect, lis pendens is dealt with, that is the borrower selling it to another person after the High Court judgment and when the SLP of the auction purchaser is pending. Not selling it, transferring his rights to another third party. So lis pendens is dealt with very elaborately till date the law traced, and res judicata traced, and Thomson Press in lis pendens, whether to add them or party, what rights are affected, whether how much is affected, section 52 of the transfer of property, and then holding that the SARFAESI, it is a 9th sale notice which was never challenged before the Supreme Court in the entirety of the arguments. So there is the argument was there is no direction to give back possession in the judgment, main judgment, so therefore there is no contempt. That angle is also replied in this judgment, answered in this judgment, which says you don't need to, certain aspects need to be inferred from a judgment. So therefore, and even we have set aside that High Court judgment, we have told you to return the money, we have told you to return the documents and the title deeds to the auction purchaser. In one word, we have not written possession to be given. Would it mean that there is no direction to give possession? So it is amounting to an act of contempt. So therefore, but they stopped from any action, initiating any action against the contemnors. Instead, they said, we'll give you some time before which you will have to come back and return the possession, etc. So in this judgment, what is now said is that the right to, under 13.8, 13.8 is only in respect of right of redemption which is lost at that point when the sale notice is issued. However, the paragraphs in this judgment, which will be certain paras, which I can probably, if you want, I can tell you also, which only says that what is stopped, the process or the sale proceedings, if there is any violation, that has not been dealt with in this judgment. So according to me, it is still a point that we can argue, even assuming you have a challenge under 13.8 also, but our rights under, as a borrower, under the violations of the rules, under this SARFAESI rules, are still not foreclosed by this judgment, is our, is something which is a food for thought, and we can always argue. Because if this judgment is coming to a conclusion at that portion, just one portion, which will enable you to understand this better, it's just one thing. Yeah, I'll just finish it. So, you have to just, I will give you the paras. If you want, I'll give it to Mr. G.Seshagiri. So I think by this, what we are now, understanding is that under 13.8, the presently as it exists also, there is a shift in the right to redemption, and also this has been in 2023 SEC Online, Surinder Pal Singh also deals with, and day before yesterday we saw one judgment was given. It was actually given in December, but Justice Nagaratna has recently also delivered a judgment following Selir, in which she says that even in that case, it was a agreement holder who was holding a property who came to the court saying that I have a right to redeem, and I have not been given a notice by the bank under 13.8 anyway when the sale happened. Justice Nagaratna in her judgment says, like in Suraj Lamps, Delhi's transactions were said that you cannot give a sale without a registered document. So Section 54 Transfer of Property Act also she takes and then says, unless there is a registered sale, the person has no right. So even to come to the court and say, I have already a document of title, there is no document of title, so therefore you don't have a right to notice. So therefore under 13.8, your rights are lost as soon as there are notice is given. So Selir is followed. So today we have to only know that the new provision 13.8 operates, and the Rule 9 also operates. And thank you very much. Sorry I've taken much of your time. I hope it was a little clear for you. Thank you. Yeah.
Thank you, Mohana. Excellent presentation. Various judgments you covered nicely. Thorough preparation. It's a very, very tough topic, job. I can understand. Now I request our Shekhar Preja. Earlier also he addressed our Friday group.
Yes.
Now he is giving vote of thanks.
Thank you.
Please, Shekhar,
Thank
please
you.
come.
I must say my three colleagues, Bhavya, Gokul and Sri Priya, actually helped me in preparation. They did the excellent job of educating me in this. Thank you.
Thank you very much.
Thank you for giving me an opportunity. It's always privilege to give the vote of thanks to Madam Mohana.
Yeah.
She is well versed in all criminal and civil. Today, I will start from her speech that she says that equity will not supplant the substantial law. This is the ground norm of today's lecture for the regions. She has set out that the Transfer of Property Act, Section 60 onward, there is an equitable right to redeem the mortgage, there is a right to foreclose the mortgage, but how this right evaporates when the SARFAESI Act comes in, and more so when its amendment has come. She has nicely explained what is the right of redemption, what is the foreclose, who can redeem the property, who can mortgage the property, what are the subsisting rights, when the right to mortgage the property vanish or evaporates, when even there is a change of the law with respect of pre-amendment, post-amendment, because the pre-amendment she nicely says unless until it is registered under Section 17 of the Indian Registration Act, because the section 54 of the TPA says that your interest is created only when there is a registered document. So therefore, C has nicely elaborated. Then subsequently, post amendment, C has says only when there is a sale certificate is issued, or even then prior to that, when there is a publication for public notice, then your right is evaporates, because once the publication is decided to be published, then the right of redemption, right of foreclosure, whatever it is, it's a bank's right which take the upper field. It's basically, she has rightly pointed out section 35 and 37, which has the overriding effect, notwithstanding whether the state acts or whatever the right you have prior to that. So SARFAESI will take place. It's nicely elaborated. At least a 10 years course have been finished in 1 hour.
Thank you very much, sir.
Thank you.